is on estate planning, and that falls squarely under the educational part of our mission. So let's get started. Just a note, you're muted. We can't hear you and we can't see you, but there is the opportunity to interact, and we really want you to do that. We want you to ask your questions. At the bottom of the screen, you'll see a Q&A button. Click on that and put your questions in there, and we'll get to them either during the program or at the end of the program. So let me introduce our guest today. Our guest is Joanne Leifheit. Joanne is a private practice attorney specializing in navigating families through estate planning, probate matters, guardianship, and more. Throughout her career, she's also served as an adjunct faculty member of UW-Madison Law School, as well as Marquette University's undergraduate pre-law program. Joanne is passionate about supporting older adults and helping their families prepare for the future. She's based in Pewaukee, Wisconsin. If you've seen our first two webinars in this series, the format's going to be a little bit different today. Joanne's going to be holding a conversation on estate planning and other financial matters with our Director of Outreach and Education, Jeremy Adi. So welcome, Joanne, and I'm going to bring Jeremy in as well.
Thank you very much, Gary. We'll wait for Joanne to get her computer. There we go. How are we doing today, Joanne?
I'm doing well. Thank you for your patience with my great technology skills.
The beauty of this is you and I are the only ones who know about it, Joanne. So
until I just spilled the beans, right?
Right. So Gary gave a great introduction of you, but do you want to give us a little bit of background, who you are, what you do, and what your experiences are in?
Sure. I've been practicing for around 24 years. And the emphasis of my practice is working primarily with adults and seniors in many areas, including estate planning, such as drafting powers of attorney and wills and trusts, in addition to special needs trusts, asset protection trusts. In addition, our practice here includes probate administration, trust administration, guardianship, and everything that falls under the umbrella of, or those areas that do fall under the umbrella of elder law. Love what I do, and I appreciate the opportunity to come and speak. I love educating on estate planning. On a personal level, spend most of my free time out in the country. I'm a big animal lover. I usually show up with cat hair and dog hair and horse hair all over me, own a horse, and love to camp. So that's a little bit about me personally. And as Gary said, I'm located in Pewaukee.
Well, thank you. And I think for those listening, a lot of the stuff you just touched on, we're going to talk about today. So the first thing I'm going to go into, and I hear it a lot, but I don't think we all fully understand what it is. Can you explain a little bit what estate planning is and what are the things people should be considering if that's an option for them?
Sure. Estate planning really encompasses, I think, two categories of planning. One includes the documents that can be really helpful to any of us during our lifetime. And primarily those documents are powers of attorney or advance directives, and I'll talk about those. But we tend to think of estate planning as far as what happens to us and what happens to our assets after death, who's going to inherit, how they're going to inherit, and how we can structure those kinds of things. So it's a combination of lifetime planning and after death planning, where I want to get to know my clients' goals and provide for individual protection and also asset protection during that process.
Okay. And I think you hit on a couple of important things there that we want to touch on. It's not just for people who have huge assets. It's for everything you have and also trying to plan for your future going ahead, correct?
Correct, absolutely. Absolutely. So when it comes to estate planning, the size of the asset base really doesn't matter. All of us need the protection of basic documents such as powers of attorney and basic wills or direction on basic means of estate planning. So it's essentially for everyone. Yes.
Okay. So you've talked a little bit about power of attorney. You've mentioned it a couple times. I hear somebody say, well, I have a healthcare power of attorney, and then I also have the overall power of attorney, financial power of attorney. Can you explain the difference of those and why they are very different and why they're important to have somebody in both those roles?
Sure. The importance is, well, first of all, we could talk about the consequence of what happens if we don't have one or both of those documents. So for anyone age 18 or older, if there's an unexpected event, it could be a car accident, it could be an unexpected health event, or it could be a progressive illness or disease. There may come a point in our lives when we are not able to communicate with healthcare providers or manage our own finances. And if we don't have both of these documents, we may become the subject of a court proceeding called a guardianship proceeding. And a guardianship proceeding is where the court is appointing a person or persons to manage both the healthcare aspect of our lives and the financial aspect of our lives. Sometimes both, sometimes one or the other. And then depending on if we're in a facility or not, there may be a third component of that, which is a court order allowing us to be placed in that facility. Well, in guardianship cases, we have, for the most part, lost the ability to nominate and direct who we want. And if we get to that point where we become the subject of a court guardianship proceeding, we've lost the ability to keep that decision private. It's not that court guardianship proceedings are public, but now other attorneys and the courts are involved in our lives. So it's a very, it can be, a stressful and taxing experience that we can avoid by putting documents in place in advance. Those documents are called healthcare powers of attorney and durable financial powers of attorney. And it is what it sounds like it is. The healthcare power of attorney allows us to designate someone, including alternates, to step in and manage our healthcare affairs and decisions if we're unable to do so. Likewise, there's a document called a durable financial power of attorney that allows us to privately name someone to step in and manage the financial aspect of our life. So if we have drafted these documents, we get to make our own choices and essentially exert as much control over our lives as we're able to under some, really challenging circumstances. And we're also keeping the court guardianship proceedings out of our life. And I would mention that, once the court gets involved in a guardianship for any person, the court remains involved unless we recover and we can come back and show the court that we can now once again manage our affairs. But if we're unable to do that, there will be court involvement until we pass away. So that's a great level of interference that we can easily avoid by thoughtfully planning and having these documents drafted for us.
I think the way I'm hearing it, Joanne, is by having the documents put together, it stays personal. I can talk to my friend or family and tell them, whereas if it becomes a court guardianship, it becomes very impersonal. They don't know me. We've never had a discussion. They don't know what my wishes were. And now I'm at their mercy to make decisions. And it may not be what my will or intention was before that incident happened. Is that correct?
Well, oftentimes the court may appoint family members as the guardian, and oftentimes the subject of a court proceeding may have discussed their wishes with that person. But in order for the court to appoint the guardian, we have to go through a pretty complex process to get there. And so it's that type of process that we're hoping to avoid. But on the flip side, if you are taking the time to have powers of attorney drawn up, and in my opinion, we should all do that, you should also be making a point to talk to the persons that you're naming in those documents. Legally, we call those persons agents. You should be making a point to talk to them about what your wishes might be under certain circumstances and what decisions you would want them to make on your behalf. So it's much more of, it's an intentional process. And those of us who are executing powers of attorney are doing so that we can convey our wishes, so that someone is standing in our shoes and knows what we want. That may or may not happen, that those conversations have occurred with someone who's under a guardianship proceeding, but we want to go about it very intentionally.
From your role, one of the things you just talked about is communication. Really talking to the family member, friend, whoever it is going to be, and really sharing what your wishes are. Do you help facilitate that? Because I know in my experience, I've seen a lot of people where they're hesitant to have that discussion. They feel it's morbid to talk about if I get sick, and so they have trouble having that discussion. So is there any role you play in helping facilitate that discussion?
Well, I definitely encourage all of my clients to have the discussion. I'm definitely more than happy to sit down if one of my clients believes that they need some additional support during that conversation. And, I agree that family members may be a bit, oh, whoa, I don't want to hear this. I don't want to talk about that. But regardless of whether the conversation takes place one-on-one with my client and their family members, or if I facilitate it in the office, I'm more than happy to do that. There are also lists of questions that I print out for my clients that they can take to family members and discuss. And I think, part of the process is encouraging the other family members that, look, these are important conversations to have, even though they're hard to have. And not only do I want to talk to you about these issues for myself, but you should be talking to someone about the issues also. So we have to do our best to gently push back the resistance to have those conversations. It's important that we do.
Absolutely. I think I've shared with you, Joanne, I had a support group a couple of years ago where we talked about this issue, and a husband and wife sitting next to me got in an argument because they'd been married 50 years but had never had this discussion. And his wishes when he died were very different from what she thought his wishes should be. And that discussion became quite interesting. It got resolved eventually, but I think it's important to have that conversation with your spouse and family members and anybody else. And I think you giving off the questions really helps probably hopefully helps get that conversation started. Beyond communication, what are other things I should be considering if I'm choosing a power of attorney?
Well, I think first and foremost, without question, is you want to be naming a person or persons that you trust, because there's a lot of power in these documents. And not only do you want it to be naming people that you trust, but especially with the healthcare system, someone that is going to be a good advocate for you. And you may list, one person or one set of people as alternates in your healthcare document, and then a whole nother group of people in your financial document, because someone may be very skilled at staying organized and balancing checkbooks or reaching out to financial professionals if there's a need. And someone else may be a little more familiar with the healthcare system and serve better in a role to work through that system on your behalf and to really be a good advocate for you. Now, sometimes in some families, the family member who's being named in that role is the same person. but you really want to give thought to who in your circle of family or friends is best to serve in that role. So I put, trust and advocacy really high on my list. Oftentimes clients are asking me how much distance, in terms of physical distance, should be taken into consideration. And that's a little tougher. It might be easier, for example, for a child or a family member who lives close to you to serve. It might be more convenient. But I always encourage my clients to also think about who's really best in the role. In this day and age, it's not as difficult to manage a person's affairs if there is a bit of distance involved. There is Zoom, and there is email now, and the phone, and online methods of handling banking and some of those kinds of things. So you do have to take distance into consideration, but I would still put trust and advocacy very high on my list.
Thank you. I appreciate it. I think the advocacy one is one we forget about. I think it's great to have
Yeah.
somebody who's gonna fight for you, gonna really dig into those questions and not just kind of, nod their head and agree. So I think advocacy is great. And I think that's a good example, Joanne. So I guess the last thing I'll ask you when it comes to power of attorney before we go on to some of the other stuff is, how do I legally make somebody my power of attorney? I can't just say, Joanne, you're my power of attorney, and now everybody has to follow that. There's got to be a process there. Can you kind of explain what everybody goes through to make sure that we're doing that properly?
Sure. There are documents that we use to get powers of attorney in place. So let's talk about the healthcare power of attorney first. Many hospitals and healthcare providers have developed their own forms, their own healthcare power of attorney forms, and those are very good. There is also a document that you can look up called 5 Wishes, and there is a Wisconsin version of that document that's excellent. And the state of Wisconsin also has a model healthcare power of attorney that is very straightforward, but yet very effective. And any attorney that you work with, typically as part of helping you with your estate plan, can and will draft those documents for you, both the healthcare and the financial power of attorney documents. So there are many ways to get the healthcare document completed. If my client comes in and has previously executed a healthcare power of attorney, I always want to see it, because I call those documents deceptively simple. They need to be witnessed appropriately, and the right people need to be witnessing them. For example, a family member cannot witness, and a few weeks ago, I had a client who had a family member serve as a witness, and you can't do that. Also, there are some yes or no questions that are generally consistent among all of these forms, and you want to be answering the questions in the right way. So sometimes the answer you want to give may not be the best answer for you legally. So I want to look through that document also. Also, I find that someone may have prepared and signed this document, 10 years ago, and they forget who they've named as their agent, and they may want to make changes or add someone, in which case I'm assisting them to get that done. So that's kind of the long and short of the healthcare power of attorney. For the financial power of attorney, attorneys routinely draft these, and in my opinion, an attorney who's helping you with this will give you a really solid legal document, a really solid financial power of attorney. Those attorneys who work with seniors as part of their practice are going to give you, in my opinion, a more comprehensive financial power of attorney. so that we can deal with some of the issues that we face later in life, most likely such as long-term care. So in my opinion, I like to see seniors and adults have financial power of attorney drafted by an elder law attorney. But having said that, there is a state form that will, allow a family to get this done. I have to say, I see the state form filled out incorrectly a lot, and I mean a lot. So on the financial end, if I have a preference, I prefer that my client have me draft that document. If a document's drafted and it's not witnessed appropriately, or something is not answered in the best way legally, it's just as if you don't have the document, and essentially you can end up the subject of a court guardianship proceeding anyway. So, I recommend having attorneys review those documents and possibly consider updating them.
I appreciate it. I think that helps people kind of explain, I can't just pull it off the internet and fill it out. We really want to have it reviewed. I want to hone in on one thing you said there and maybe ask you from an attorney perspective. You talked about, you want to look at that form on occasion because maybe you don't remember who you assigned as your power of attorney, or heaven forbid, the person you assigned 5 years ago has passed away and you forgot to change it. How often do you recommend people review those documents and make sure that everything is accurate and, no names have changed and things like that?
There is no definite timeline. If there is an event such as someone passing away or grandchildren being born, or several people have moved and changed addresses, or your wishes change. So there is no set timeline. So usually we say if there's a life event, you should really think about coming in and having everything looked at again. I think a 3 to 5 year guideline is fair to catch most changes in people's lives.
Thank you. We'll shift gears a little bit now. We've been talking power of attorney, but you talked about wills and trusts a little bit. Can you explain the difference between a will and a trust, and how you would help people with that?
Sure. So wills and trusts have some things in common. Both documents, for example, both documents allow us to designate a person or persons to be in charge and manage our estates if we pass away. And both documents have a written plan for what all of us want to see happen if we pass away. And by that written plan, I mean that everyone has goals as to how they want to see their assets distributed. It may be that we want charities to receive a portion of the estate. It may be that we want to make sure we're helping to pay for our grandchildren's education. It may be that there's a person in the family with a disability, and we don't want that person to inherit and lose their public benefits. Or it may be a child of ours that might potentially face divorce, and we want to protect or added protections to our estate planning documents so that that child's share would not get split up in a divorce. So the plan is multifaceted, and it goes in writing in both documents, both the will and the trust. But a couple of differences, and they're pretty major, are how wills are administered and how trusts are administered after a death. A will is administered through the court proceedings or through the court system in the probate division in what's called a probate proceeding. So probate is a system that is prescribed by law, where the person who's administering the estate, by the way, that person is called an executor, or in Wisconsin, we call them a personal representative. So the personal representative is following a set of procedures and steps that are prescribed by law in order to administer the estate from start to finish. And this process is a process that the court oversees. And so from start to finish, you are within the court system. So the system in and of itself is a good system, but it can take time to get through the system. I would say, we're talking anywhere from 6 months to a year and a half to get through the system. It's all going to depend on the person's particular estate and what's going on and how diligent the personal representative is. The system does come with some expenses, and many personal representatives, not all, but many will hire an attorney to get them through the process. So it becomes a time-consuming process with some expenses associated with it. It's also a public process. If I pass away, for example, anyone can go online and see, the sum total of what's going through my estate and figure out from the court records who's inheriting. So some of my clients wish to make some different choices as far as their estate plan, and that is through the use of a trust. So the trust is also going to put someone in charge after death, as I mentioned. The trust is also going to have my written plan for how I want my goals to be achieved in the document. But a trust is administered privately and not within the court system. So that's a huge difference there. I will mention that attorneys handle trusts in a little bit different ways. Here in my office, we do a lot of the legwork up front and walk our clients through that. And by legwork, I mean that in order to avoid court, the assets have to be coordinated with the trust in one manner or another in order to accomplish the goal, which is to avoid court. So we help our clients through that process. So it's a much more involved estate plan. And the way I explain it is that we're putting a lot of legwork in up front, with the goal being to avoid the legwork and the court system and that court process that comes after we pass away. So it's a much different way of estate planning. And I have clients who make the choice to go both ways. It all depends.
I appreciate that. I think that hopefully gives them a good explanation of the difference between the two, because I think you hear them interchangeably once in a while and they seem very different in a lot of ways. So I think that's important. One of the things you and I have talked about in the past is revocable living trusts. Can you explain a little bit what that is, and again, how it benefits people when they're using that?
Sure. So the word revocable in a nutshell means that the person creating the trust has the ability to fully control the trust assets, and make changes to the trust and withdraw assets from the trust. It's what I call a very client-friendly document, in that you're not getting too tied up when you create the trust. What you're really doing is, if you pass away, you're keeping matters private and you're keeping them outside the court system. Even so, it's friendly in the sense that you can make changes to the document, you can pull assets in and out. So that's what a revocable living trust is. And I'll contrast that with an irrevocable trust. Well, let me back up a second. So if I am using a revocable trust, since I have control of those assets, I have to use those assets to pay my creditors and to pay for my care. So I'm really, in most instances, I'm not protecting those assets. A different type of trust, called an irrevocable trust, is where I'm giving up some controls in relation to that asset, but I'm also taking the asset out of my estate. That is what I would call more or less an asset protection trust, meaning that it will avoid court, but we're not putting it in place for the primary purpose of avoiding court. We're putting it in place for the primary purpose of protecting assets. So just to kind of lay a foundation for this, the most common trust used for estate planning is a revocable living trust, because it accomplishes those important goals of avoiding court and avoiding the probate system and allowing our matters to stay private if we pass away.
Before I jump to my next question, we actually just had somebody ask a question in the Q&A, and I'm going to do my best to read this fully because there may be a few questions on it. But the individual is asking, is a family trust able to be protected from, say, a nursing home charges over the years? And if beneficiaries are listed but not yet activated, would it be helpful to have that done even if not needed at the present time? The example they use, that would make 4 versus 2 people having claim to the trust. So I don't know if you fully got all that, but I can repeat it if you need to.
Yeah, could you
All right.
repeat it?
Yeah, is a family trust able to be protected? Try that again. Is a family trust able to be protected, say, from a nursing home charges over the years? Let's go with that one first.
Okay, so when any of us create a trust, we can give it any title that we want. And we may throw in irrevocable or revocable in the title, or we may just call it a family trust. But it's the terms and provisions inside the trust that tell us whether it's that friendly revocable trust or a more strict irrevocable trust. So to answer this question, if someone has a trust titled, you know, the Smith Family Trust, I, as the attorney, I don't know if that's revocable or irrevocable until I read the document. The document is going to tell me one way or another. And if the trust is revocable, now I always have to see a document before I give an opinion. So I'm going to be talking in generalities today. I just have to do that unless I'm meeting with a specific client looking at a specific document. But generally speaking, a revocable trust, the assets in a revocable trust are going to be open to creditors, including a nursing home. Generally speaking, most of the time, an irrevocable trust, depending on the timing of when the assets were put in and the terms of the trust, generally speaking, those assets are more likely to be protected. So just the term family trust doesn't give us enough information to answer the question. I need to look at the terms of the trust and do a little further analysis from there. And in general, a revocable trust is going to hold assets that are subject to paying for long-term care. And in general, an irrevocable trust has the likelihood of protecting assets. So it's a deeper question, or, you know, there's a lot to answer to get that question answered. So that's about the best I can do.
But I think it gives them a good idea, Joanne, that they probably want to talk to whoever drew up this trust for them and talk to them about that to see what is protected and what isn't. And their attorney is going to, it's no different, Joanne, than if we have a doctor on here and you ask a doctor about, well, I'm on this medication, and this one. They don't know you and your history. They're going to ask that, you know, we need to see more. And I think that's how you answered it very well. The other part of that question then was asked, if beneficiaries are listed but not yet activated, would it be helpful to have that done even if not needed at present time? So would it be helpful to have the beneficiaries activated, or is it okay just to have them listed and then they're activated when the trust goes into effect?
So I'm struggling to answer that question because I don't quite understand the question. And I'm just kind of at a loss of how to approach that. Maybe as we're talking, if the person who posed the question can give me a little more detail in that question, I'll be able to answer it, because I'm always happy to answer questions.
Okay.
But I just don't know where to start to take a stab at that one.
No problem. And you know who posted it, so if the individual who posted it wants to clarify that a little bit, that would be great. And the good news is, Joanne, a bunch of other questions came in while we were talking, so I'm going to go to those for a little bit.
Okay.
They cover a lot of what you and I have touched on. One person just asked, can I have both kinds of trust? Can I have an irrevocable and a revocable trust? So can you have both types?
Yes, you absolutely can. And what I tell my clients is that that might be an ideal way to manage your estate. And here's why. If you place assets in an irrevocable trust, you are placing the assets there in order to, let's use the word protect them, but you should not be using those assets. So you don't want to take your entire estate and plunk them into a trust that you can't utilize for your daily care. In my opinion, you want to leave some assets out so that you can pay for some of your care and you can meet your needs. And so as part 2 of that estate plan, you might choose to put the assets that are not going in the irrevocable trust into a revocable trust. So yes, I think that that is a viable and good option to consider.
The next question is always a loaded question, so I'm going to give you a heads up on that one.
All right.
It says, what is the approximate cost of your services for the discussed documents, and what is that based on? So, the cost of services for some of the documents, I think the caveat, and you're probably going to say, Joanne, is it's going to vary from place to place. If you live in the Milwaukee area, it's probably going to be a little different than if you live in Madison or Green Bay or elsewhere. So each area is going to be a little different, but I'll let you kind of touch on, what is the approximate cost of this?
Yeah, that really, really is a hard question for me to answer. I think that, many things are going to come into play. One is the complexity of the client's situation, the complexity of the plan that the client wants in place. And so, here's what I do. I offer a consultation at no charge. And what I ask in return is that clients who come in for that consultation complete an intake questionnaire so that I can get to know them and sit down and figure out what their goals are. And at the end of that initial consultation, 9 times out of 10, I am able to give a client, I try to give flat fee quotes. So everyone is different. And so that quote is based on the amount of complexity and the amount of time that I'm going to be spending on that estate plan. So that's the way I do things because everyone is different. And rates for trusts and the quality of work from attorney to attorney just differs. I would say that, for trusts, you can range anywhere from 1,000 to 10,000, depending on whether it's revocable, irrevocable, the number of assets that need to be coordinated with the trust, and every attorney is just going to come at it with a different approach. So it's not that I don't want to answer the question. I just don't have a great answer to give you. And that's why even with my own clients, I don't quote until I've met with them and I've discovered what their goals are and what direction they want to head. So a very hard question for me to answer, and it's not an unwillingness. It's just, I don't know.
Right. Well, that's kind of, like I said, it's a loaded question because it can vary from person to person and really what they need, and then how much time it's going to take you to do it. So I completely understand that answer.
Yeah.
Another question that came in was, I believe our revocable trust becomes irrevocable when one of us dies. Is that possible? Does that happen? That I can have it as right now it's revocable, but when somebody dies, it becomes irrevocable?
Yes, it's possible to make a trust, irrevocable upon death. I would want to look at that trust and see what parameters, meaning essentially what the trust says, because that wouldn't necessarily be a typical trust that I see. And I'm not saying it can't be done. I'm not saying that at all, but I would want to see the trust, before I told you for sure what I think about how those terms read, but yeah, it's possible.
Okay. All right. I'll go back to my questions now. We've answered some from the audience. The next one I had for you, we've talked about living, revocable, irrevocable trust. One of the other ones I hear every so often is special needs trust.
Mhm.
Can you explain a little bit what that is and if that would be beneficial to people with Parkinson's disease or not?
So a special needs trust, well, let me back up. Sometimes persons who have a disability um, will apply for certain public benefit programs. Certain public benefit programs are more of an entitlement. In other words, if you qualify due to your disability, you can receive the benefit. Other public benefit programs, you have to qualify for from a financial standpoint, meaning that you have to show a financial need before you can get on the program. And we call those needs-based public benefits. So let's say, for example, that I'm on a public benefit program that is needs-based. And let's say that someone leaves me an inheritance. If that inheritance, and I'm just going to talk generally, I would need less than $2,000 to get on that needs-based public benefit. So if I receive an inheritance, it's likely going to be over $2,000. Then my asset limit will be so high, I will lose that public benefit program. So what has happened is that the federal government has allowed persons with a disability to create a special needs trust. There are different kinds of special needs trusts. If it's my money and if I'm the person with the disability, I can create my own. If a family member wants to give me money that I can use and draw off of, that's called a third-party special needs trust. So there are different ways to structure these, but the bottom line is that it's a way for a person with a disability to remain on their public benefits and have some money set aside for certain needs. One thing I'll say is that the government designed the rules around these special needs trusts and how they work, and it can be quite complex. For example, if one of my benefits is SSI and money comes out of the special needs trust to help me pay for rent, for example, that's going to reduce my SSI. So these trusts are, it takes some knowledge to administer them properly. But to get to your question as to whether a special needs trust could potentially help a person, yes, yeah, that definitely may be the case. If there is a disability and if the person wants to go on or is on needs-based public benefits, and if there's another source of funds, even if they're the person's own funds, we could send those funds up to what we call a first party special needs trust and allow those public benefits to continue. So it's really great. It's a great thing that the government recognized that it's really hard to live on $2,000, next to impossible. And so there is a way to kind of protect some assets and still use them. One distinction, Jeremy, that I want to make is that if I am the person with a disability and I send money up to a special needs trust, that's called a first party special needs trust. If I pass away, certain government programs may try to reclaim what they paid out before any remaining balance can go to my other family members. So we call those payback trusts. But during our lifetime, they will allow us to remain on the public benefit programs. So that's a special needs trust, an overview of what they are.
Thank you. That's very, very clarifying. I appreciate that. We're doing great. I've had so many questions coming in. I don't know if we're going to get to all of them in the next couple minutes, but we actually just had one come in on Facebook Live. I live in rural Wisconsin. how do I find a qualified estate planning attorney to help me with some of the issues we're talking about? Is there a way to find elder law attorneys throughout the state that you're aware of, Joanne, that people could tap into?
Yes, there are a couple of ways. One might just be an internet search for elder law attorney. The State Bar of Wisconsin also has a lawyer referral service that you can call and ask for an attorney who specializes in elder law. One of my favorite ways of finding attorneys who more than likely are qualified in elder law is to go to a website called NAELA.org, NAELA.org, and that's the National Academy of Elder Law Attorneys. And you can search for an attorney by location. You can put in your zip code and say you want to search within 50 miles. And I have found in my experience that attorneys who belong to that organization generally really care about elder law issues and are generally very informed and good at what they do. So that's an idea you can use. The State Bar has an elder law section, and I'd say many or most attorneys who practice in elder law might be a member of that section. I don't know if I guess the State Bar could tell you probably best. You can also make a call to the State Bar and they might be able to tell you. So.
Excellent. I appreciate, especially the NAELA. I think that's awesome. And it was NAELA.
Yeah.
.org. Perfect. Yeah. So it looks like Carolyn's putting it in the chat, but it's NAELA.org for anybody looking at it. Yeah. Another question in the chat came in, and we touched on this a little bit earlier, but we can go back to it, and I'll read you. His question is, how important is a trust if I have assets? If assets already have beneficiaries assigned to them, can a will be satisfactory for that?
It can be, and what I want to do before giving my clients an answer to that question is I want to sit down and get to know them better, and I want to know what their goals are, and I want to know about the beneficiaries, and I want to know much more about that client and what the client wants to achieve before I answer that question. And I'm not intending to be vague, but I will talk this through with clients and see if that's the right way to handle their situation based on their goals, based on the beneficiaries, based on what they're trying to achieve. But for some of my clients, yes, we will put a will in place and then allow the beneficiary designations to stand. And yes, I have a fair amount of clients where we will talk it through and decide that another plan is better. So, estate planning, I can be pretty comprehensive, and I want it to be tailored to the client.
And I think that's a good answer, Joanne. I mean, you keep saying I don't want to be vague, but I do think people understand, just like Parkinson's disease, each will, each estate is specific to that individual and what their goals are, what their assets are, et cetera. So I think hopefully our audience appreciates that, it is going to be different, but I think you're giving some good answers over the general question. So here's one more that's come in, and this may be our last question, we'll see. If there are 4 active beneficiaries, does each person have quote unquote control over a quarter of the trust, such that they should one beneficiary enter a nursing home, only their 25% can be used to pay their care bills? Or does the trust consist of assets gifted to someone? Are there any protections within that? So I guess, if we have $100 and there's 4 of us in there, is my sister only in charge of $25 and that's all she gets? Or are they eligible to more within that trust based on what their needs may be? I don't know if that makes sense.
Yeah, this is, and I think that the person who's posing that question probably circled back on the question I couldn't answer earlier. So a couple of things. This is really still a tough one to answer. Just because someone's named as a beneficiary in a trust doesn't mean they're entitled to anything, because in most trusts, the person who created the trust can change who the beneficiaries are. But let's say that that's done and these 4 people are going to inherit. It's going to depend on how the trust is written. I would say, talking generally, if a person is entitled to a 25% share, then the nursing home potentially would only be able to get that 25% share if the person actually inherits it. So I would, again, I would want to see the trust, and I would want to see how it's written, and I would want to know more about the circumstances. Because if, let's say, for example, the parents created this trust and the parents are still alive, well, many things could change between now and the time the person with the 25% interest actually inherited the money. So I'm sure I could get to the bottom of that question, but just based on the question alone, I don't know that I can answer it very well without further information.
Well, I appreciate it, Joanne. I'm going to direct people right now. If you go to the chat button, Carolyn has put, or our communications director, Carolyn, has put a couple of the websites that Joanne mentioned earlier. Joanne, is it okay if we put your website and contact information in that chat feature as well for everybody?
Sure. No, I'm happy to have that information on there, and a moment of self-promotion. I'm happy to consult with people about their estate planning. I do want to mention that if someone's coming in to talk to me primarily about Medicaid, I do charge a fee for that type of consult. Also, I give monthly workshops where I cover the same topics that we've been discussing today, and there's no charge for those workshops. So anyone is welcome to sign up for those workshops also.
Well, thank you. I see your website's already been put in the chat, so people can go there and find more information about Joanne. I'm going to thank you so much, Joanne. This was different than what we've done in the past with some of our presentations, but I think the amount of questions we had, I think it really hit a nice spot for people. So I appreciate your time. I'm going to step off stage left. I'm going to bring Gary Garland, our executive director, back on to wrap everything up. But thank you very much, Joanne, and have a great day.
Okay, you're welcome. Thank you for having me, and anytime I'm happy to answer questions. So, all right, I'll sign off now. Bye now.
Bye.
Okay.
I'll echo that. Thank you from Jeremy. Joanne, thanks for taking a topic that as Jeremy had mentioned earlier, often can bring up some fear, some confusion, and helping make that topic a little bit clearer. And certainly, I think the biggest takeaway is get the ball rolling. We all need to be thinking about estate planning, and often that can get the beginnings to find out really what you need for low or no cost with folks in Joanne's position. So a couple things I want to mention just before we say goodbye to you. As we mentioned earlier, these recordings are available. This one will be up, I think, within a couple hours on our website, wiparkinson.org. So check that out and check out the other resources there if you haven't been to our website. Couple save the dates. Friday, July 30th is our annual symposium, and that's the program we hope to and expect to have a in-person and a virtual component. Pretty soon at our website, you'll be able to register for that. If you've been to this program before, you know it's just a one-of-a-kind program you can't get anywhere else, with great Parkinson's experts. Whether your role is whether you yourself have Parkinson's or you're a caregiver, there's going to be things throughout that day to learn and take away. And if you love to golf, or if you just love to eat, you can do both those things at our annual golf outing, which is going to be September 14th. We'd love to have you there. It's going to be at the Legend at Brandybrook in Wales, Wisconsin. So as well, some information on our website about that. And then in closing, 2 ways we could really use your help. In a very short time, you're going to get an evaluation. We do that for all of our programs. It's literally going to take you about 5 minutes to complete, but it gives us so much good information about today's program, about other programming you want to see from Wisconsin Parkinson Association. We are driven by you, so we need your input. So please, when you see that today, take the time to complete that, and that will be a big help to us. The other is you've been to these programs before. We always want to remind you, we love providing these programs, and we do them free of charge. Everything we do is free of charge, but not free of cost. So we rely on just giving. We don't have a membership, which we used to have in the past. We rely on voluntary giving, and I know a lot of you watching are already supporters of ours, so thank you. I also know that many of you are not in a position to give, and that is understandable and fine. Our programs will remain free of charge. But if you're in a position where you have benefited from our programs and in your position to give, we want to encourage you to consider that gift today. And when you get the evaluation today, you'll have that option as well there. So just want to thank you again for joining us today, and have a great rest of your day. Thank you.